Um, our sixth question, Cheryl, on this subject is: can employers withdraw flexible working arrangements where they are no longer in their interests?
Well, once agreed, a flexible working arrangement is actually a permanent change to the employee's contract, so it can't be changed again without further agreement between the parties, although you are at liberty to say that it's temporary or subject to a trial period. When you're doing that, obviously, you're going to make a final decision further down the line. You're going to need to agree that extension to the decision period when it's a trial period. If it's temporary and they've only asked for it temporary, it's not a problem. However, in many cases anyway, it's going to be the employer's interest for the new working arrangement to be permanent, because it's not always easy to accommodate these requests. And once you've accommodated that request, then a return to the previous working pattern where work's got to be rearranged again, potentially you've got an employee that was recruited to cover the remaining hours, then that in itself, changing it back could cause us as many problems as changing in the first place. But once a flexible agreement is made, it is permanent, and if an employer then makes unilateral changes to it, then you're going to risk a claim of breach of contract, and again, possibly a claim of constructive dismissal, and even give rise again to discrimination claims dependent on the circumstances. For example, the duty to make reasonable adjustments continues, not just until it's not convenient for the employer. So there's a lot of pitfalls in trying to reverse the decision once it's been made.